Justice Minister Ronald Lamola has defended his decision not to comply with 3 orders instructing him to place convicted Ishmael Moshoeshoe on parole. Moshoeshoe, who's serving a life term for the murder and robbery, wants the minister jailed for defying court orders. He instructed his lawyers to take the matter to the High Court after realizing that the 3rd order found the minister to be in contempt. Newzroom Afrika's Mnisi reports.
In his last-minute bid to stay out of jail, Justice Minister Ronald Lamola says his failure to comply with court orders issued in favor of convict Ishmael Moshoeshoe was due to his failure to properly serve him the papers of all his applications.
The first point of investigation is the Department of Correctional Services, and why? It is because the State Liability Act Section 2 is quite clear that in this type of matters where the minister is a party, the process must be served on the head of department. It's quite clear. And within 5 days, it must be served on the state attorney.
This is the first application by Moshoeshoe that Lamola is opposing. Moshoeshoe believes the judgments were never erroneously granted.
Our submissions are very simple in respect to this. We say 1. 3 judges of this court, including 2 senior judges, have considered this matter. They were satisfied with the type of service that was effected. Now, there cannot be anything that any other judge who can consider this matter would say, I was not aware of it. That's their main contention, my lady. Their contention is that you have not complied with the law. You have not served the state attorney. But we simply say 3 judges were happy with the service. They've applied their minds. And they said, that's it. We're granting orders. We don't see that there is any other judge that will see it different. They have not put up before this court anything that is tangible that we would say, at least another judge, would say if Judge Kumalo was aware of this fact, he would not have granted that order.
Lamola's legal team insists it has filed an application for a rescission and wants the execution of the orders to be stayed. But Moshoeshoe says the application was not issued properly.
The rescission application, even if, for argument's sake, your leadership is with my learned friend that the rescission application was not issued properly. But this is not the issue for this court to decide. That is a matter that can be debated when the application for rescission is dealt with. For now, it suffices that there is an application for rescission which is even on case lines, and it was also annexed to the affidavit, the answering affidavit of the first respondent.
The issues too is that it's not issued, and what they have placed before you, it does not address whether they have a bona fide defense in the review application. Because if I'm right, the leadership would be inclined to suspend the court orders on the basis that she is satisfied, at least on a prima facie basis, that they have a bona fide defense. But somehow, they seem to suggest that, well, they will explain that in the review application. They will explain the reasons why they have a bona fide defense in the review application. But in what is been placed before the court, there's none for us to make up our minds to say, well, indeed, this might, on a prima facie basis, constitute some sort of like an evidence that the court can accept it to say, no, let's wait, there's a prejudice.
Lamola's lawyers say the authorities acted in good faith and investigated the matter as soon as it came before their attention. But Moshoeshoe says they didn't act even when sent an email to follow up on why the minister had not complied with the orders. They say the department only filed papers the day after they were served for this urgent application to have the minister jailed. Judgment has been reserved. For Newzroom Afrika on Channel 405, I'm Mnisi at the High Court in Pretoria.